who exactly is afraid of knowing who voted? A response to the left's meltdown over Trump's election integrity executive order. On the 31st of March, 2026, President Trump signed an executive order titled Ensuring Citizenship Verification and Integrity in Federal Elections. I read it every single word. I was looking for the outrage. I was ready to find the constitutional overreach that justified the wall-to-wall meltdown playing out in real time across every left-leaning media outlet in the country. I didn't find it. What I found was something fairly straightforward. Something that, if you described it to a reasonable person without the political framing, would probably be met with something close to a shrug and a, well, yeah, obviously. And yet, 20+ Democrat attorneys general are organizing unified litigation, Chuck Schumer, with the practice gravitas of a man who has never once passed up a microphone, announced they would see the administration in court, and they would win. Oregon's attorney general called it unconstitutional. State election officials from Maine to Arizona vowed to fight it. The reactions were immediate, coordinated, and intense. That reaction alone should tell you something. When people that loudly insist mail-in voting is completely secure turn around and sprint to the courthouse to stop a barcode verification system, you have to ask a basic question. If it was already secure, what exactly changes? What the order actually does. Here is the part where I do the thing most of the people screaming about this order apparently skipped. I will summarize what it actually says. The Department of Homeland Security, working through U.S. Citizenship and Immigration Services, and coordinating with the Social Security Administration, will compile a list of confirmed United States citizens in each state. This will draw from federal naturalization records, SSA data, and the existing SAVE program, the Systematic Alien Verification for Entitlements, codified at 42 U.S.C. 1320b, 7, which has been used for decades to verify citizenship status for federal benefit programs. The list gets transmitted to each state's chief election official no fewer than 60 days before any regularly scheduled federal election. States can supplement, modify, or dispute entries. Individual citizens can access their own records and correct any errors. The U.S. Postal Service, directed by the Postmaster General, will initiate proposed rulemaking within 60 days. The core requirements: all outbound ballot mail must go in envelopes marked as official election mail, bearing unique intelligent mail barcodes that enable precise tracking. One envelope, one vote. States notify the USPS at least 90 days before an election if they intend to use mail-in balloting. They submit their verified voter list to the USPS no fewer than 60 days out. Ballots only travel to voters confirmed on that list. The USPS coordinates with its Inspector General and the Department of Justice on any suspected unlawful use of the mail in connection with election materials. The Attorney General is directed to prioritize the investigation and, where appropriate, prosecution of state or local officials, contractors, or private entities that issue federal ballots to individuals not eligible to vote. The order also directs that states preserve all election records for a 5-year period. That is the totality of the order. Verify citizenship, track ballots, one ballot per verified voter, prosecute people who cheat, keep records. I understand this is somehow controversial. I do not understand why it is controversial. Those are different problems. The Postal Service and the Constitution. Here is where the left's constitutional argument falls apart so completely it is almost embarrassing to watch. Article 1, Section 8 of the United States Constitution explicitly grants Congress the power to establish post offices and post roads. The USPS operates under Title 39 of the United States Code. Section 401 gives the Postal Service broad authority to regulate the classes of mail it handles, the conditions of delivery, and critically, the standards for items it will and will not transmit through the mail. The left is currently arguing in court that the federal government does not have authority to set standards for how the federally operated mail service handles federally regulated election ballots in federally administered federal elections. I want you to sit with that sentence for a moment. Count how many times the word federal appears. Now, explain to me how the federal government lacks jurisdiction. The Elections Clause, Article 1, Section 4, provides an additional layer. The times, places, and manner of holding elections for senators and representatives shall be prescribed in each state by the legislature thereof. But the Congress may, at any time, by law, make or alter such regulations. The Help America Vote Act and the National Voter Registration Act are both explicitly cited in the Executive Order's Authority section. Congress passed both of those laws. The administration is not acting outside of them. It is acting through them. Routing mail-in ballots through verified, trackable, barcoded official envelopes is not an overreach of postal authority. It is the straightforward application of that authority to one of the most consequential uses of the mail in the entire country. If the USPS can regulate how you ship a pork loin overnight, it can absolutely regulate how a federal ballot travels to and from a voter. The argument that states have exclusive plenary authority over federal elections to the point of nullifying federal standards is historically incorrect. That argument was made in different form, in a different era, by a different party. It did not go well then either. The fraud they keep telling me doesn't exist. I have been told, with considerable condescension, that election fraud is rare, debunked, and a conspiracy theory. I have been told this by people who simultaneously cannot explain the following numbers. Michigan's own qualified voter file showed 271,566 more votes cast than voters who voted. Pennsylvania certified results with 121,240 more votes than voters. In the same state, 71,893 individuals received voting credit for mail-in ballots returned after Election Day. Maricopa County in Arizona had no documented chain of custody for 740,000 ballots. Arizona accepted 20,500 mail-in ballots after Election Day, 18,000 of them arriving on November 4. California, where the state attorney general went to court to stop a ballot count, saw a sheriff seize ballots and find nearly 46,000 more votes than ballots physically in evidence. These are not accusations. These are documented discrepancies from official records and state-level proceedings. If you want to tell me none of them matter, you are welcome to try. But the courts dismissed the cases is not the same thing as we examined the ballots and everything was fine. Cases were dismissed. Ballots were never physically examined. Those are not the same outcome. And confusing them deliberately or otherwise is intellectually dishonest. Meanwhile, in 2025, a federal grand jury in Arizona subpoenaed Maricopa County election records. An FBI investigation is ongoing. Justin Heap, the newly elected Maricopa County recorder, had his power stripped by the outgoing recorder before he could take office, which a judge subsequently ruled was improper influence on official proceedings. For a system that has nothing to hide, it certainly fights every attempt to look at it. The barcode system in this executive order addresses a specific documented vulnerability. The absence of any reliable way to confirm that a mail-in ballot traveling through the postal system arrived from the person it was sent to at the address it was supposed to go to and was returned by that same person. You can call that a conspiracy theory, or you can call it a logistics problem with an obvious fix. I am a science teacher. I deal in data. The data says the fix is needed. The SAVE Act, what it is and where it stands. I want to address the SAVE Act specifically because it is related to this conversation, but is not the same thing as the executive order, and the distinction matters. The Safeguard American Voter Eligibility Act, H.R. 22, would require documentary proof of U.S. citizenship to register to vote in federal elections. Acceptable documentation includes a real ID, a valid U.S. passport, a military ID, combined with a birth record showing U.S. citizenship, or a birth certificate paired with a photo ID. The bill passed the House of Representatives. It has not passed the Senate. It has not been signed into law. It is not currently in effect. I am telling you this because intellectual honesty requires me to. Unlike certain other people in this conversation, I believe accurate framing matters. The SAVE Act is a legislative proposal with majority popular support polling consistently shows 76% of Black Americans, 80% of Hispanic Americans, and 80% of white Americans support requiring proof of citizenship to vote, but it has not cleared the Senate, and I will not pretend otherwise. What the executive order does accomplish is a parallel track, using existing federal databases to compile and transmit a verified citizenship list to state election officials. This is not the SAVE Act. It does not require states to do anything about their registration processes. It creates a tool, a federal citizenship verification list, that states can use to cross-check their voter rolls. It is supplementary, not mandatory in the registration context. The SAVE Act would be the permanent legislative solution. The executive order is the administrative infrastructure that should have existed already. They are not the same bill, but they are not incompatible either. And the fact that Senate Democrats are blocking the SAVE Act while simultaneously suing to stop the executive order tells you exactly where their priorities are. Quinn's Law, #23. Liberals love the law unless they don't agree with it. Then they just don't obey it. You need ID for everything except voting. I would like to walk through a partial list of things that require government-issued photo identification in the United States. Buying certain cold medications containing pseudoephedrine, boarding a commercial aircraft, opening a bank account, renting a car, purchasing alcohol, purchasing tobacco, picking up a prescription for a controlled substance, applying for federal benefits, entering a federal building, renting an apartment, getting married, buying a firearm, adopting a pet from some shelters. You also need photo ID to attend many Democratic National Committee events. Senator Jon Ossoff required photo identification at his own town halls while voting against federal voter ID legislation. The DNC has required photo ID for credentialed entry at its national conventions. Now, imagine I told you that the one activity that determines who governs a constitutional republic of 330 million people is the only thing on that list that shouldn't require any verification whatsoever. Imagine I told you that requiring a citizen to confirm they are in fact a citizen before receiving a federal mail-in ballot is somehow more burdensome than proving your age before purchasing a six-pack. This is the position being litigated in federal court right now, with a straight face, by people calling themselves advocates for democracy. The argument that ID requirements are racist has been tested in Missouri's Supreme Court, where the NAACP and League of Women Voters challenged the state's voter ID law. The court upheld it. One plaintiff testified she could take Uber, could walk reasonable distances, and had already successfully voted by provisional ballot. The court found that requiring ID creates no legally cognizable burden when alternatives exist. Free IDs are available in virtually every state. Provisional ballots are available for anyone who lacks ID on election day. The argument does not survive contact with the actual legal record. The reaction is the confession. Quinn's Law #2 states, if you want to know what liberals are up to, pay attention to what they accuse conservatives of doing. For 6 years, I was told I was trying to suppress votes by asking questions about chain of custody and ballot verification. The accusations were that election integrity advocates were the ones trying to rig the system. And now 20+ state attorneys general are in emergency litigation to stop ballot tracking barcodes. And citizenship verification, things that would make it harder to stuff ballots, harder to send ballots to non-voters, harder to return someone else's ballot. Things that protect the integrity of every legitimate vote cast, including the votes of every Democrat voter in every one of those states. If your stated goal is protecting voting rights, and someone proposes a system that makes every verified citizen's vote more traceable, more secure, and less susceptible to cancellation by a fraudulent ballot, you should welcome it. Unless the votes you were protecting were not entirely from verified citizens. That is the logical inference available from the behavior on display. I am not making that accusation. I am noting that it is the only interpretation that makes the reaction make sense. At a 2026 White House signing event, the administration was explicit. This order ensures states are provided with a comprehensive, verified view of who the eligible voters in their jurisdictions actually are, allowing them to confirm that everyone voting in their elections is legally able to vote. The Postmaster General's office will implement barcode tracking so that mail-in ballots can be traced with precision, not guessed at, not approximated, but actually tracked the way any other piece of certified, time-sensitive mail is tracked when it matters. The people suing to stop that are not defending democracy. They are defending opacity. And opacity in an election system is not a civil right. It is a vulnerability. The communist goals they won't want you to read. On the 10th of January, 1963, Congressman Albert Herlong read into the congressional record a list of 45 communist goals for America, drawn from Cleon Skousen's research in The Naked Communist. Several are relevant here. Goal hash 5, capture one or both of the political parties in the United States. Goal hash 20, infiltrate the press. Goal hash 38, transfer some of the powers of arrest from the police to social agencies. An election system that resists external verification, retaliates against officials who attempt oversight, litigates against chain of custody requirements, and generates documented discrepancies that are dismissed without examination is not a secure system. It is a controlled system. The systematic resistance to election integrity measures across decades, across states, across every proposed safeguard is not organic. It is coordinated. And coordination at that scale toward the goal of maintaining an opaque, unverifiable election infrastructure is precisely what Goal Hasson 5 looks like in practice. I am not saying every Democrat official is a communist. I am saying that the behavior aligns with the playbook in ways that are too consistent to be coincidental, and that people who love their country should find that at least somewhat alarming, regardless of party affiliation. A word on the litigation. The cases will go to federal court. Some will go further. That is the appropriate process, and I will not pretend otherwise litigation is legitimate. But let me outline the landscape. The administration's constitutional footing is not thin. The Elections Clause gives Congress explicit authority over federal elections. Congress has delegated considerable implementation authority to the executive branch through the Help America Vote Act and the National Voter Registration Act, both of which are cited in the order. The USPS operates under statutory authority, 39 U.S.C. 401, that grants it broad regulatory power over mail classes and delivery conditions. The SAVE program, 42 U.S.C. 1320B7, has been used for decades to verify citizenship for federal benefit eligibility. And its application to election verification is a logical extension. The plaintiffs will argue that the order effectively nationalizes elections in violation of the state authority granted by Article 1, Section 4. That is the best argument available to them. But Article 1, Section 4, explicitly includes the congressional override, but the Congress may at any time by law make or alter such regulations. The administration is operating through laws Congress already passed. That override clause exists precisely for situations where state administration of federal elections becomes inadequate. The states fighting this order are not fighting for state sovereignty in any principled sense. California, Oregon, and Arizona are three of the states with the most documented election irregularities in recent cycles. They are not fighting this on principle. They are fighting it because it would close specific vulnerabilities that currently exist in their systems. That is not a constitutional argument. That is a tactical one. The bottom line, I want to be very precise here, because precision matters. If you are a United States citizen, this executive order changes nothing about your fundamental right to vote. You will still be able to vote by mail if your state allows it. You will still receive your ballot. It will arrive in a trackable, barcoded envelope. Your name will have been verified against federal citizenship databases before that ballot was sent. When you return it, there will be a record. One ballot, one voter, one count. If you are not a United States citizen, you will not receive a federal mail-in ballot. This is already the law. It has been the law since well before Trump's first term, 18 U.S.C. 611 makes it a federal crime for non-citizens to vote in federal elections. This order adds the infrastructure to enforce a law that already exists. The SAVE Act, if it eventually clears the Senate and becomes law, would add a registration-level layer of citizenship verification. That day has not yet arrived, the Senate blocked it, but the executive order stands independently of that legislative process, and the legal framework supporting it does not depend on the SAVE Act passing. When Chuck Schumer says, "See you in court," he is not defending democracy. He is defending a system that produces 271,000 more votes than voters in Michigan, 121,000 more than voters in Pennsylvania, 740,000 ballots with no chain of custody in Maricopa County, and California attorneys general in court trying to stop people from counting ballots. He is welcome to defend that system in court. I am interested to see how that goes. But what do I know? I am only a science teacher and Army combat medic who actually read the executive order, the constitutional provisions, both federal statutes cited, the election discrepancy data from 6 swing states, and the legal record of every major court challenge before forming an opinion rather than reading a press release and calling it research.